EU's data protection regime in practice, implications and learnings for Turkish businesses. So today he will be discussing where we are, what the current status is in the EU, but with a tailor-made perspective into how this gives a guideline or a map of anticipation for the businesses in Turkey. Dr. Flemming Moos is a partner at Osborne Clarke in Hamburg and a German certified specialist lawyer for information technology. Flemming focuses on data protection and technology law and has more than 15 years of experience in advising European and international companies and navigating them successfully through the European data protection law minefield. He also has the firm's international data privacy service line. Flemming is a well-known expert for data protection, to say the least, and privacy law in the European legal market and abroad. We're honored and happy to have you with us, Flemming, and if you could take the stage, it's your turn now. Thank you.
Thank you very much, Gürkaynak, for this very kind introduction. Welcome, everybody. Good morning. Thank you very much for having me to this interesting talk. It will be a challenge to explain a bit the European data protection law in a half hour, but I'll try my best. I've been introduced enough, I think, so I'll start right into the topic. Who of you is already aware with the new rules in your Turkish Data Protection Act? Many have read it already. Who is confused? Frustrated? Angry? Okay, so those who are angry, I would like to apologize for, because I don't know whether you're aware of who actually throughout the world enacted the first data protection laws. It was the Germans, exactly. So in a way, I feel a bit responsible for what you have on the table now, even though I was not involved in the lawmaking process as such. Therefore, I'm very grateful that ELİG and EY invited me here to explain you a bit what it's all about, and to help you understanding it, what in the 1970s already, the ideas in the 1970s, the Germans thought about data protection law. Now, this is me. And this is the program. So we want to talk about a bit, first of all, data privacy principles in a nutshell. So what are really the main principles of EU law, as they are also reflected in your current laws, because as most of you are well aware, it is actually based on these principles from the directive, and it actually implements lots of these provisions. So it's also for the understanding of your current laws, very good to focus on what is the directive about. Then I'll try to explain a bit how in the practice actually you can ensure compliance with the new laws, and give you a bit of best practice approach how businesses within the EU do this with respect to the EU laws, and look a bit about what is actually best practice, how to do it. And then at the end of the talk, I'll be touching upon 3-4 hot topics, issues at the moment, because as you also might be aware, you might have thought, certainly in the EU we deal with this law, the directive and data protection laws, for more than 20 years, but still not everything is clear and settled. So there are still many areas of insecurity, of questions, what is compliant, what not. You'll appreciate that technological developments pose constant challenges to the question of what is in compliance with data protection laws and not. And we'll just focus on 3 points where you see there's some movement. 3 major points in advance in order to assess what is actually data protection law about. One of the most important questions is what is actually personal data. I've seen in your maps, which you do have on your seats, and maybe also have looked at it. In the journal from ELİG, there's an article about this question, so if you want to dig deeper into it, I recommend you read that. So what is personal data? Why is this important? Because the definition of personal data decides about whether you actually have to comply with all these data protection requirements or not. Only if and to the extent you collect and handle personal data, you will be subject to the new rules. So the good thing would be, if it is not personal data, you can ignore the law, right? So then you don't have any obligation under the new laws. The downside is, at least within Europe, and this is backed by the case law of the European Court of Justice, the notion of personal data is really, really broad. So this is the definition coming from the directive, and it has two main elements. Basically, it says it's any information related to a person. The law says to an identified or identifiable individual. So any information, you see, it could be any kind of information. And sometimes the tricky question to decide is whether it relates to a natural person or not. This is pretty clear in circumstances where you have the name, or it is related to the name of the person. So if this is the case, any information which sits in a database, which is related to a name, is considered personal data, and you have to respect the laws. But also, it would be sufficient if you don't even have the name, but there is a certain way how to get to the name. Very easy example, in your employee files, you might have the name somewhere, but in many databases in which you process employee data, you just use an employee ID, for example. That does not mean it's no longer personal data, because you're able to attribute the data of the employee ID to the actual employee with his name is all personal data. So a very broad concept, unfortunately. Then maybe three more basic terms and definitions which are important to understand the new laws. The law applies to any type of processing of this personal data. And again, this term is also very broad. It includes basically any kind of handling of personal data. It starts with the collection of personal data, but it also includes transfers of personal data, storage of personal data. Even anonymization of a data is a way how to handle personal data, which is governed by data protection laws. So again, in this regard, there is basically no type of handling of personal data which would be outside of the scope of this law. And then two other important terms, because this is an important differentiation in the laws. It is the differentiation between a data controller and a data processor. The data controller is the entity who is responsible for data protection law compliance, and this is defined as the entity who decides about the purposes and the means of the processing. So the one who is really responsible for defining where to collect data, for which purposes to use, etc. And he has the burdens of compliance, basically. And then you have data processors. These are mainly entities which act under the control of a data controller, and they just merely handle data, but it's more like technical service providers. For example, if you've outsourced your information technology services, an outsourcing service provider would typically act as a data processor, and he would not as such be responsible for complying with the laws, but only the data controller would be. Now and then I thought very briefly we might touch upon the really 8 major principles of data protection law as they are enshrined in the European rules and as they are reflected in your new laws. So one of the major principles is that data must be processed fairly and lawfully, which also means that for any type of collection, use, transfer of data, you always need a legal basis, so either a statutory provision within the law which explicitly allows the handling of the data, or a consent of the affected individual. There are no other means how to justify this, right? So you either need a consent or a specific allowance. Then the principle of purpose limitation, which is also very important. You're under an obligation to collect and process personal data always for defined certain purposes, and you cannot, without having a justification again, use them for other purposes. So for example, if you collect data in the course of the conclusion of a contract with your customers, and then you decide to use them for marketing purposes, this might be okay, but you have to check whether this processing for other purposes, for marketing purpose, is also allowed, because you either have a consent or a statutory basis which explicitly allows it. So you always have to connect the lawfulness of processing to certain defined purposes. Third one, processing must be adequate, relevant, and not excessive, which means that you always have to ensure that you only use and collect data to an extent which is really required for the certain purposes for which you use it, and don't collect data which you don't need, don't store data longer than you need it for the actual purposes. So this is also an important principle. And fourthly, the fourth major principle, data accuracy. Data shall at all times be accurate and kept up to date. So if data is not true or outdated, you might also be under an obligation to delete it, or the data subject might have a right to demand correction of the data. 5, this is also connected to the third principle. I've already mentioned it, to the principle of necessity. This also means that data must not be stored longer than actually necessary for fulfilling the purposes. And then 6th point, data must always be processed in accordance with the rights of the data subjects. There are numerous rights which the data subjects have with respect to the data. He has a right to access the data, to be informed about how you treat personal data. Under certain circumstances, he might be entitled to demand deletion or correction of the data, as I mentioned. So there are many rights of the data subjects which need to be taken into account. 7, appropriate technical and organizational measures. Data protection is not only about protection of the data, it's not only about data security, as we've just learned, it's more about protecting the individual to which the data relates and ensure that his rights are not, his rights are respected, basically. But it also has a technological angle, which means that you also need to ensure that they're adequately protected technologically. So you have implemented the necessary technical and organizational measures to ensure data security, basically. And finally, there is an additional burden in case you want to transfer personal data to a recipient outside of the EU, if we take the EU view. Because it needs to be ensured that wherever the data is being transferred to, there is an adequate level of data protection. Because, as you know, not every country in the world has a data protection law. It needs to be ensured that the data is not transferred and outsourced to the country where there's no adequate protection, and thereby circumvent actually the rather strict provisions which we have already for a couple of years, and which you now have implemented too. So this is basically the main 8 principles which you need to take into account and which underlie the data protection rules. And now I thought it might be a good idea to give you an overview of how to implement it as a best practice. we think that it is easy to grasp if you try to divide the obligations under the data protection law into 6 areas of compliance which are there. The first and foremost obligation is, of course, lawful data processing as such. So you need to ensure that the data you collect and process is in accordance with the necessity principle. You do have a valid basis for it because you have consent, etc. So the data processing as such must be lawful. But this is certainly not all. This is only one element. There are other important elements to it as well in order really to have a proper lawful data protection management system. The second tier of obligation relates to the data protection organization of the business. We'll touch upon certain obligations in these 6 fields later on. I'll just name now the six areas here. So there are questions of how you need to set up the business and how to define responsibilities within the business in order to ensure compliance. Thirdly, the law requires you to implement certain processes and procedures. One or several I've already mentioned, for example, the rights of the data subjects, right? So they are entitled to data access, for example, or to a correction of the data. You need to implement a process within your business to ensure that these rights are actually fulfilled. So if there is a customer of yours and sends an email to your company and says, I want to know which data you store about me, you need a process how to comply. Fourthly, I've already mentioned technology and data security. So there's also always a technological angle to it because you need to implement technical measures, as I said, in order to protect the data properly. Then a fifth area of compliance relates to policies and documents. So the European rules include some provisions which directly require you to have certain documents in place. For example, a consent in case you base the processing of personal data on the consent of the data subject. Or another example would be where you engage a data processor, someone who's processing the data on your behalf, on behalf of a controller. There the law says you need to have a certain agreement, a data processing agreement in place in order to justify this forwarding the data and engaging a data processor. So there are direct obligations within the laws which require you to have certain policies or documents. And finally, an obligation around accountability and documentation, which means that you should be able to prove that you actually fulfill all the other 5 obligations. Under our current laws, so the European Directive 95/46 and the national laws which implement these obligations in a very similar way as your new Turkish data protection law does, this is of some importance, but it's even of more importance under our new laws, which will take effect from 2018 on. There, this accountability is a really, really very major principle, and it will gain much more importance. But still, it's also important. Why? Because as a data controller, as someone who decides about which data you use, you are responsible towards the data subjects, but also towards the authorities, and therefore you need to be able to prove that you're in compliance. So all these 6 elements should form the pillars of a data protection management system, how we call it, which ensures that you actually fulfill all the requirements under the data protection laws. Now, what are basic compliance measures. Again, this might not be a full list. You will see on the next slide for each of these 6 areas some basic compliance measures, as I call it, according to best practices, what businesses in the EU do in order to fulfill these obligations. I think as a standard, this should cover most of the things the businesses need to implement, depending on the business and on the type of data they use and the processing activities they have implemented. There might one obligation not be relevant, others might be relevant, but having generalized it a bit and trying to give you a best practice overview, I thought these would be measures that you should at least consider in order to comply. I think we would not run through every obligation which is on the next slides, but I thought for you, I think you get them as materials afterwards, right? Presentations. So for you as a backup, really, to have like a checklist, which types of processes I need to implement. Maybe just to give some examples. First area of this 6 compliance areas, data protection organization. Maybe we touch upon the first point. You need to define, in particular, if you act in or for a group of companies, who of those is the data controller that I mentioned, and who of those may be just data processors who handle data on behalf of other companies. So you need to define who are actually the responsible entities. For example, you have a group of companies, and you have one HR system, for example, where you process your employee data. You need to assess and decide, is it every single entity who is responsible for data protection law compliance for their own employees, or is it rather the mother company who decides about which data to use from employees, etc., and is the mother company the data controller for all employee data? So this needs to be assessed in the first place. Then there are a couple of basic compliance measures regarding lawful processing. For example, first of all, of course, the basis is you need to track your data processing activities and actually know which data you collect and for which purposes, because we've seen the principle of purpose limitation is very important. And then, for example, if you look at the obligation below 2F, in case there's no other justification for the type of data you process, you need to collect a consent. So you can run through these obligations, as I said, basically as a checklist to see what are the compliance measures I need to implement. The same goes for documents and policies. Again, what are best practice measures which companies use? For example, again, just as an example, if you look at 3D, for example, you know that this is very common in the online world. You are under an obligation to inform the data subjects about how you use personal data. Best practice, and you know that already, is what you call either privacy policy or data protection declaration, which you make available maybe on your internet site, so that people can see and read and understand which data you collect from them, how you use them, etc. So having such a document is one of the best practices in this area. Technology and security, we can make it short. It's any kind of security measures like encryption, for example, etc., but also technical measures which help you fulfill other obligations. For example, if you look at 4C, if you need to correct, delete, or block personal data, it's mostly technology which allows you to do it. So also as a means to fulfill your other obligations. And the fifth area, processes and procedures. We've already talked about some of these. For example, this one is also an important one, 5D, engagement and auditing of data processors. But again, just as an example, if you use data processors in the course of IT outsourcing or whatever type of IT service, a cloud service which you use. You need to check whether he's fit for purpose, so to speak. He has adequate data protection measures implemented. You need to conclude a contract, so there you need a process how to engage him. And afterwards, check that he actually complies with the contract that you've concluded. And finally, sorry, this was too quick. Accountability and documentation. There you'll have some measures how you could implement this. As an example, if you base your processing on a consent, make sure you store this consent, you document it. So if it is in written form on paper, it's easy, you put it in a file. If you do it online via a click, make sure you log this so that you can always say, I've collected the consent because I've logged it. This is, yeah. So briefly as an example, and then I might stop already to allow maybe 2 or 3 questions. I think we have a question round afterwards altogether, but just an example of how these 6 areas of compliance come into play in a particular scenario. So think about your marketing department, which intends to start a new campaign and wants to collect customer data, including their email addresses in the course of a raffle or some other marketing activity, and approaches you and said, okay, I want to do this marketing activity. The emails later on shall be sent out by a marketing agency. So now, how do I do it in compliance with data protection laws? And there you see how these 6 elements fit perfectly together. First of all, in order to ensure that you have an adequate data protection organization in place, you have to define who's the data controller, who's the entity responsible for collecting the data in the course of this raffle. You need to ensure data is adequately processed. So what data do you use? Which is the particular purpose? Is there a legal basis? Can you base it on the law? Or do you need consent? These are the questions which you have to answer in the second field. You need to inform the customers about the purposes for which you use the data and the fact that you use the data. So you need a data protection declaration, data privacy policy which covers this. Maybe you need to draft a consent because you need it for sending them marketing emails. Maybe you need to update your internal registers to make sure you document the process that you implement. You need to implement data security measures and possibly delete the data as soon as they are no longer necessary. Processes and procedures, I already mentioned this as an example. You need to check if you want to engage the marketing agency. It seems to be fair to engage them as a data processor, so you need an agreement and you need to check that they actually comply with their obligations under the agreement. This does not. And finally, if you base it on consent, for example, in the field of documentation, you need to ensure you log and retain the consent, and you maybe also need to audit the processor to ensure I have checked and done everything that is okay. So maybe this exemplifies a bit how these 6 elements work together in practice. Do you have 2 more minutes, or? Yeah, okay, thank you. Maybe just very briefly, because as I said, I mean, data protection law throughout Europe is very settled already, but there are still some open issues and some challenges. Where should I put it? Is that, okay, perfect. And you will face these challenges too. So I think it will be fair to say after this session, you will possibly not be able to implement everything. I'm aware that the secondary legislation for Euro law in Turkey is still missing, so there are still some open issues which need to be solved in future. And here are some critical issues and challenges which we face in the EU at the moment, and which will certainly also impact you as a business. First one being international data transfers. I don't know whether you're aware of the decision by the European Court of Justice with respect to the so-called safe harbor. So this was the regime which was put in place in order to adequately transfer data to the US. In October 2015, the European Court of Justice says the decision of the Commission, which considered this instrument to be adequate, is void. And after that, there have been long discussions. What are the requirements? What can be an alternative scenario? How to justify it? Now we have the EU-US Privacy Shield. It's, so to speak, the successor of the safe harbor. Whether this complies with the requirement, nobody knows. There's some hope in the market. There are already, again, legal proceedings before the courts, and it is definite that this question will end up at the European Court of Justice as well, in order to assess whether this is an adequate instrument, or whether this also fails the test by the ECJ, and whether other measures are required to justify international data transfers. So there are loads of uncertainty around that area, and I'm pretty certain as soon as the Data Protection Commission in Turkey is established and they assess what is required for adequacy, you will face the same challenges, actually. Security of data is under constant challenge, in particular due to cybersecurity attacks, which are getting more and more relevant. So this is also an area where you might need to assess in more detail how should your processes and procedures be designed in order to be able to defend your business against these new attacks. This isn't rather a legal question, but it's more a factual question, but it gets more and more important. So in this regard, it's not only it's not sufficient just to look in the laws and basically do what you're required by law, but actually look at the actual threats that are out there. And finally, maybe the third one, profiling and analytics and big data, so really like the new data processing technologies. As you will appreciate, the directive which we have at the moment in the EU dates from 1995. None of these data processing activities were known or implemented at that time. So the law doesn't answer what are the requirements to do analytics, to do profiling, to use big data technologies. So there's a lot of uncertainty around it. And this will even not go away with the new law, which will be implemented in the EU in 2018. It has always been said over the 4 years in which they've created the law that it should be future-proof. But in fact, it's not really. So if you think about it, it's a huge law with 99 articles and 173 recitals. How often do you think you will find the word cloud computing in this law? Not a single time. So there you see all those modern data processing activities. They're actually not really reflected there, so there are a lot of uncertainty around what is actually legal and what not, and I'm pretty sure you'll face the same challenges. I've already talked about the regulation, so we are already in the second stage of getting a new data protection law. You're in the first one, so it's very good, I think, to see what are the experience elsewhere. From 2018 on, there will be some additional obligations if you have activities within the EU. So just to warn you, there will be another compliance obligation which you might be subject to. Happy to take some questions now, maybe one or two, I don't know if we got time for that. This is our blog on the EU Data Protection Regulation, so if you want to have a closer view of what comes in 2018, visit eudatareg.com. Otherwise, I'm happy to take your questions, maybe one or two now and then the rest, or let's do all of them together. Okay, perfect. Thanks for your attention, very kind. If you're in the break, you have any questions, I've got two colleagues in the room, Charlie and Sona. Would you say hi so that people recognize you? You can also take your questions with them. Thanks very much indeed.
Flemming'e teşekkür ederiz. Gayet bilgilendirici bir sunum oldu.